Witnesses to the domestic violence might include family members, co-workers, friends, neighbors, and police officers. It is best to talk to witnesses before the hearing to find out what they may have seen or heard that will help your case. Remember that any witness who testifies must have personal knowledge of an act of domestic violence committed against you. For example, you may want a neighbor who has helped you and can testify about your demeanor and any injuries you have had. You should think carefully before deciding to have any children testify in court. Courts are also very careful about permitting children to testify in domestic violence hearings. Always tell the judge right away if you want to have a witness under the age of 18 testify. The judge will want to know who the parents of the child are and exactly what you think they will testify about. Although there are no clear rules, as a general practice, judges do not like to have children under the age of 7 testify. When the child is between 7 and 13 years old, there are no general guidelines. Courts may be more willing to hear testimony of a child 13 or older, especially if the child is the only witness to an act of domestic violence. The decision about whether or not a child will testify is made by the judge. Any person who is a witness in your case must come to court and testify because the court will only consider live testimony from a witness. The only way to legally order a witness to attend your hearing is to issue and deliver a subpoena to that witness before the date of the hearing. A subpoena is an order to a person telling that individual that he or she must attend the hearing and give testimony. It is a good idea to do this even if the witness is a friend or family member, because the subpoena will show his or her employer why he or she must miss work on a certain day. Testifying in court, telling the judge your story, can be a very stressful experience. It is a good idea to think about what your testimony will be before getting to court. You might also find it helpful to write out your testimony. You want to think not only about your current incident of domestic violence, but also the history of domestic violence that you experienced. After you write out this information, it is a good idea to think about each incident and determine if there are any relevant witnesses or evidence that you can present in court. Please note that you will not be able to read from this paper in court. It is only to help you prepare beforehand. After you determine what your testimony will be, you should compare it to the contents of your temporary restraining order. If you would like to testify to incidents for which notice is not provided in your temporary restraining order, you may want to amend the temporary restraining order. This means you should go to the county courthouse, preferably before the date of your final restraining order hearing, and tell the staff at the Family Intake Unit that you would like to add information to your temporary restraining order. A new temporary restraining order will be created and served on the abuser. Also, while preparing for the final restraining order hearing, you should gather your physical evidence. This may include broken items, photographs, torn clothing, medical records, or any type of electronic recordings. Remember to bring these with you the day of your hearing. Whenever you go before the court to present your case, professional and modest attire should be worn. It is not advisable to wear clothing that is ripped, ill-fitting, bears offensive language, or is otherwise inappropriate for a business setting. If you are being represented by an attorney, arrange a time and place to meet at the court on the day of the hearing.
If you need legal advice or representation, you can see if you are eligible for our services by calling 1-888-LSNJ-LAW or completing our online intake at www.lsnjlawhotline.org.